Chapter 9 looks at sentencing goals and sentencing philosophies, as well as sentencing structures. So while the sentencing process can sometimes seem to be pretty straightforward, especially to the general public, it's actually pretty complex. Deciding upon our proper sentence is based on what we see the goals of punishment as being. So we've got 5 main sentencing philosophies, and we're going to talk about each one of these. So retribution is one of the earliest forms of punishment. And it basically embodies the idea of lex talionis, an eye for an eye, a tooth for a tooth. Retribution or just desserts also implies that there should be proportionality in punishment, so the punishment should fit the crime. Basically, under this philosophy, the reason someone is punished is because they have committed a wrongful act, and therefore they're punished solely based on what they did and the severity of that offense. So basically, these are just desserts for what has been done. So just desserts, retributive philosophy, is looking backwards at what you've done. We're not looking to rehabilitate someone, and we're not looking to deter them from committing future crime. Incapacitation, though, aims to actually incapacitate someone, thereby preventing them from committing additional crimes. Basically, what we're doing here is removing offenders from society so they cannot repeat their behavior. Usually we do this through incarceration, but other punishments like castration or capital punishment are also forms of incapacitation. The idea here is to protect the victims. One of the things we do here is we often engage in what's called selective incapacitation. This is where we try to identify those offenders most likely to offend repeatedly and to, in particular, incapacitate them. We do this through get tough laws, 3 strikes, habitual offender laws as well. Rehabilitation aims to change somebody's behavior. This is a planned intervention. Probation is rehabilitative, drug treatment, anger management. There's a lot of cynicism around this. In the 70s, a report came out called the Martinson Doctrine, which basically said that nothing works and rehabilitation doesn't work. Most prisons, though, do include some types of programs, various vocational, technical, or educational programs. Restoration is a newer goal, and it comes from this concept of restorative justice. The idea here is to repair the harm that has occurred as a result of the criminal act and return both the offender and a victim back to society. So what this does is it really includes the victim and other members of the community along with the offender in determining what the appropriate punishment is. Deterrence has 2 different types of deterrence, but deterrence is basically the idea that a punishment exists, and because that punishment exists, you will not break the law. So there's general deterrence, which is designed to discourage all would-be criminals from committing a crime. So this could be a sign you see somewhere, that says if you steal, XYZ is going to happen. Sometimes you see these signs on the highway around the 4th of July as you're driving towards New Hampshire, and they're telling you how there's a law against bringing fireworks back into the state. Specific deterrence aims at reducing the chances of recidivism for a specific person. You broke the law, you've been punished, therefore you won't do it again. Some other things to think about in terms of sentencing and the purpose that it serves or the philosophy behind it is that sentencing is also symbolic. So sometimes we see offenders are sentenced to something like 319 years in prison or 10 life sentences. Clearly someone cannot serve that amount of time. It's basically symbolic and sending a message. We also wanted to send a message not only to the offender about how serious their behavior is, but also to people who might be thinking about committing similar crimes. Another goal we often have here is reintegration, and this is related to utilitarian philosophy and how they look at punishment. So the idea here is that the prevention of future crime is part of reintegration. So what we want to do is we also want to think about once an offender has served their sentence, how we reintegrate them back into society. We want them to come back into society readjusted and to follow the rules. So today there's a lot more focus on this within the prison system. So thinking about sentencing structure, we have different forms of sentencing. Indeterminate and determinate sentencing are opposites of each other. Then we have guidelines-based sentencing and mandatory sentencing. So indeterminate sentencing is a range. Someone would be sentenced to 5 to 10 years. There's a minimum number of years they're supposed to serve and a maximum number of years. Basically what happens here is when you're released is determined by a parole board. What this basically does is it allows us to basically give the offender something in exchange for their good behavior, and it basically gives them a reason to behave while they're in prison. Determinate sentencing, on the other hand, is a fixed term. You must serve 14 months. Okay, so then your release time is determined by accumulating good time, which is deducted from your maximum term. There is no parole board discretion here. The date is just automatically determined. This also means, however, when you get out, there's nobody supervising you upon release into the community. Presumptive sentencing is also referred to as guidelines. These are fixed punishments for each criminal offense, and they're graduated according to how severe the offense is and what the offender's criminal history is. So basically, these are arranged in, ranges of months. Punishment range, midpoints are generally the presumptive number of months imposed according to the table. So the midpoint, if it says 12 to 26 months, 24 would be, 12 to 36 months, 24 would be the midpoint. Mandatory sentence is where the law basically says if you commit this offense, there's a certain amount of time you just have to serve. We have these a lot for drug laws, and currently Michigan has a mandatory penalty. If you commit a felony while using a gun, you automatically serve 2 years. So under federal law, there's 60 mandatory minimums that cover over 100 offenses. We also have habitual offender statutes, and these vary from place to place. So Massachusetts does have a habitual offender law, but we don't have a 3 strikes law. Both Washington and California have 3 strikes laws. So these are aimed at chronic, persistent, violent felony offenders because they pose the greatest risk to the public. These might be called persistent offender statutes, or they might actually be a 3 strikes law. So basically, these are people who, after a certain number of offenses, they might have to commit certain qualifying offenses, and then after another offense, they would be sentenced much more harshly. In 1994, the federal crime bill said that in order for states to receive money, that they need to make some changes to their sentencing provisions. So prior to this, people were typically serving about 40 to 50% of their maximum sentences. Truth in sentencing requires somebody to serve at least 85% of their sentence prior to being released. And that wraps up Chapter 9.